Okay. So today we're going to go over rent stabilization, including what it is, why apartments are rent stabilized, how to find out if an apartment is rent stabilized. We're going to learn about rent increases, the current rent guidelines board percentages, deregulation, how apartments fall out of rent stabilization, and then what are some of the legal remedies that rent stabilized tenants have, and then finally we'll talk about succession rights and then harassment. For those who don't know, TakeRoot Justice, we are a nonprofit legal service provider. We provide legal, participatory research and policy support to grassroots and community-based groups in New York City that are working to dismantle racial, economic, and social oppression, like Cooper Square Committee. The materials that I'm using tonight, I want to give credit to my colleagues Ryan McDonald and Cora Metric Chen, who created the original materials and a lot of what we'll be seeing tonight. Okay, so let's start by talking about what rent stabilization is and how we got it. So rent stabilization is a New York state law that also is adopted by New York City as a New York City law, and it's a bunch of rules and regulations passed by the state agency Division of Homes and Community Renewal. It is the result of years of organizing and advocacy by the tenant movement. It came into being at the end of the 1960s after the biggest wave of rent strikes in history, which were the 1963 to 1965 rent strikes across Harlem. And the original law passed in 1969. It was revised in 1974, and so we'll see 1974 as a key date for a lot of parts of rent stabilization law. Rent stabilization is broad, it has many parts, it is complex and intricate, but at base, it is about two things. One, a rent stabilized tenant cannot be evicted except for cause. Or another way to put it is when a rent stabilized tenant's lease expires, the landlord has to give them another one. And they can only be evicted if they do something wrong or for a very limited number of other reasons, which we'll go over in detail tonight. The second major part of rent stabilization is that there are limits on rent increases. The rent, when you renew your lease, can only go up by certain percentages, unlike market rate apartments, where the landlord can raise the rent whatever they think they can get somebody to pay. So apartments, for the most part, most rent stabilized apartments in New York City became rent stabilized if they were in existence as of January 1st, 1974, and they were in a building containing 6 or more apartments, right? So as of January 1st, 1974, the rent stabilization law said every building with 6 or more apartments is rent stabilized. So if your building was around then and it had 6 or more units, it became rent stabilized at that time. It may have been deregulated since then, and we'll go over the ways that that could have happened. Other than that, there is another way that apartments can become rent stabilized, even if they were built after 1974, primarily through two tax programs that the state the state and the city will give to building owners in exchange for to pay for them to either build new buildings or renovate old buildings. And when they do that through a program called J51, they get tax breaks. And in exchange, all of the units in the building become rent stabilized for as long as they get those tax benefits, which can be 10, 15, or 20 years. 421A, no longer in existence, although there is a newer, different version of it. But 421A was a program where developers who built new apartment buildings could qualify for tax exemption, property tax exemption, if they kept all of the apartments rent stabilized for a certain number of years. And the key for both J51 and 421A is that unfortunately, the rent stabilization expired when the tax benefits expired. So there are folks out there who are rent stabilized today through J51 and 421A, and there are folks who may have been rent stabilized through those programs in the past, but are no longer. Now, one or two notes I want to add to the rule about 1974 and 6 units. If the number of units in the building has changed in the last 51 years, that can affect the rent stabilization status. So if the building had 6 units in 1974 and it has fewer units now, maybe because the landlord combined units or converted a unit to something else, so then the apartments are still rent stabilized. Even if today there's only 4, 5 units in the building, uh, the apartments are still rent stabilized unless they've been deregulated by one of the other processes that we'll talk tonight. On the other hand, if a building was too small to become rent stabilized in 1974, it had, 3, 4, or 5 units. But since then, there have been units added to bring the number above 6. Then all of the apartments in the building, and not just the new apartments, but all of the apartments in the building may become rent stabilized. That is a very both foggy and intricate part of the law. So we're not going to go down that particular rabbit hole tonight, but just as a placeholder to know that if there are more than 6 units in your building, it may be rent stabilized even if some of those units are new. And importantly, even if some of those units are illegal, right? So it's not uncommon for a landlord to take, say, a 4-unit building, subdivide a couple of the apartments, get 6 or 7 units. They may not be legal. If the Department of Buildings came by, they might slap a vacate order on it. It might not follow the certificate of occupancy. But courts and judges have held pretty consistently for decades now that even if the apartments are illegal, they may still be rent stabilized. So how can you find out if your apartment is rent stabilized? There are a few things you can do. The first and easiest thing is look at your lease. If your apartment is rent stabilized, the lease should say that it is a rent stabilized lease. So obviously, if it says that, you're rent stabilized. That said, landlords may, first of all, they may be misrepresenting the status of the apartment. They might be calling it unregulated when it should be rent stabilized. They may have grabbed whatever lease form they had lying around. So don't rely only on your lease if it doesn't say rent stabilized. You can, first of all, you can look your building up in a great app called Who Owns What NYC. That if you've been to any of the other trainings in this series, or you've heard us talk about it. If you look up your address, you get a whole range of facts about the building, including not only the number of units it has now, but if those number of units have changed since 2007. And if you look up your apartment on HPD's website, which you can do just by hitting a link from the Who Owns What site, It will actually have a red flag. It'll have a note at the top of the screen in red that says some apartments in this building have been registered as rent stabilized. It won't say which apartments, and that's because the law says that DHCR, which keeps these records, isn't allowed to give that out to the public. Um, but you'll be able to see, that at least there's a chance that your apartment is rent stabilized, that at some point in the past, your building was subject to rent stabilization. And then finally, you can request the rent history of your apartment from DHCR. So Division of Housing or Division of Homes and Community Renewal is a state agency. They do a lot of different things, but for our purposes, most importantly, they oversee rent stabilization. And every year, a landlord with rent stabilized apartments is required to register with DHCR the name of the tenant in that apartment, the start and end dates of the current lease, and the current rent, as long as the apartment is rent stabilized. You can get a history of all of those registrations going back to 1984, which was when the registration requirement began, and you can have it mailed to your apartment. You can do that a number of ways. You can call up DHCR through 311 and ask them to send a copy of your rent history to your apartment. You can request it through the JustFix NYC app, which is another part of the same app as Who Owns What. You can go online to DHCR at the website here, and don't worry about writing down all the URLs. Cooper will share these slides with everybody after the fact, so you can go in and look at what the links are. And finally, you can go to the DHCR's office in your borough, although you have to make an appointment for that. And it's become so easy to order rent histories remotely that I'm not sure really that anybody does that anymore. Your rent history, right, will show every registration done by every landlord of your building going back to 1984. This is still not the final word, right? You may get something that says unregulated, uh, but it still could be that that's because a landlord at some point or your current landlord has misrepresented the status of the building. And there is a whole deep dive we could do into how to read a rent history, and how to spot red flags that there might have been some kind of fraud or improper deregulation. We're not going to do that tonight just because that could easily take up the entire evening. So we're going to do a broad overview tonight. If you do have your rent history and you're not sure about something in it, reach out to Cooper Square. The organizers are experts at reading these things. And, we're happy to jump in as well if there's something especially hard to interpret. This is what the standard rent stabilized lease renewal form looks like. It's printed by DHCR. Landlords do not have to use it, but most of them do for rent stabilized apartments. This is not the same form that you would have gotten when you moved in. When you moved in, you would have gotten a much longer lease with pages and pages of fine print. But because under rent stabilization, the landlord cannot change the terms and conditions of your lease when you renew, all of that fine print doesn't have to be reprinted. All they have to do is give you this basic form, which gives you the information about the start and end dates and your options for 1 or 2 year renewal and what the rent increases will be. So, how can a landlord increase the rent in a rent stabilized building? That has changed over the last 10 years because in 2019, the legislature passed a huge bill called the Housing Stability and Tenant Protection Act that uh, possibly some of you worked on passing. It was a massive overhaul to the rent laws, and it, among other things, changed the ways that landlords can increase the rent uh, in rent stabilized apartments. So the most common way to increase the rent is when you renew your lease. When you renew your lease, the landlord can increase the rent by a percentage that is set every year by a body called the Rent Guidelines Board, which is a committee made up of people appointed by the mayor and other authorities. It has landlord representatives, it has tenant representatives, and it has what are called public representatives. Every year they hold a series of public hearings and they vote on what the rent increase percentages will be for the next year. The other two major ways that a landlord can raise the rent in a rent stabilized apartment is by doing a major capital improvement or an individual apartment improvement, which means they do physical improvements to the building or to the apartment. And we will get into those later this evening. Before 2019, landlords could also collect a 20% rent increase every time the apartment becomes vacant, every time there's a turnover in the tenancy, which was a huge incentive to landlords to try to turn over tenants as many times as they could. They could also get what was called a longevity bonus, which is that if they're not successful at getting tenants in and out really fast and evicting them, they get a consolation prize where they can raise the rent an extra amount because, God forbid, a tenant actually lived in their home for more than 8 years. None of that is currently allowable thanks to the tenant movement. So the Rent Guidelines Board, RGB, increase in effect right now for any lease that began between October 1st, 2024 and September 30th, 2025. So the rent stabilization year runs from October 1st to September 30th. During this year, if you choose a 1-year lease renewal in a rent stabilized apartment, the landlord can increase the rent by 2.75%. If you choose a 2-year renewal, they can increase it by 5.25%. And my apologies, that's a typo there where it says year one, because last year it was more complicated and they could do a two-part increase. Increase a certain amount year one and another amount year two. This year it's straightforward, although it is high, it is 5.25% for a 2-year lease increase. The Rent Guidelines Board is currently in the process of deciding what next year's increases will be. They've held public hearings. They will have 2 more public hearings on June 17th and 27th. In fact, I think they have a public hearing tonight. And then on June 30th, they will vote on what those increases will be. So let's talk about major capital improvements. An MCI is an improvement to the building that, in the words of the law, is essential for the preservation, energy efficiency, functionality, or infrastructure of the entire building, right? So it's got to be important. It's not cosmetic improvements. It's not new wallpaper in the lobby. It is things that are necessary and actually benefit all users of the building. When a landlord does spend money on a major capital improvement, they can increase the overall rent using this formula, right? There's 2 different formulas depending on the size of the building. If you're 35 or fewer units in the building, they can increase the rent by 144th of the cost. And if it's a building greater than 35 units, it's 150th of the cost. That cost gets divided among apartments pro rata based on the number of rooms in each apartment. So bigger apartments get a larger increase. The amount that landlords could increase MCIs was a lot higher before the HSTPA, before 2019. This was one of the victories of the tenant movement. Um, it's also now true that major capital improvements they expire after, I think, 30 years. They used to be permanent. Obviously, we won't see that tested until 2049 at the earliest. So that's not a very big feature for us right now. It used to be that a landlord could just spend whatever they wanted on the work. They would submit their bills to DHCR, and DHCR would approve the increase. But since 2019, the law now requires DHCR to publish what's called a reasonable cost schedule. So they have to publish numbers saying, if you replace the roof, this is a reasonable cost. And you can't get an MCI if you pay more than that, or you can't get an MCI for the part of what you pay that's more than that, unless you can make the case that you had some kind of extraordinary circumstance. Um, Unfortunately, at least anecdotally, our experience so far has been that DHCR pretty much rubber stamps any request by a landlord to go over the reasonable cost. But it is still something we can fight, and we should fight every time there's an MCI application by a landlord. In order to get the MCI, as I said, DHCR actually has to apply to DHCR. They have to submit all the documentation, the documentation that shows what work was done, who did it, the permits, the bills, and proof of their payment. Tenants are given notice of this and can oppose the MCI on a number of grounds, including that what the landlord says was done wasn't really done. The tenants know that on the ground, that the work was actually done poorly so that it's not actually functioning the way it's supposed to, that the cost is unreasonable, or that the cost the landlord is claiming is not really what they paid, or that the landlord has a relationship with whoever they paid. So sometimes, a landlord will own a number of different corporations, a number of different LLCs. And if tenants can show that actually one LLC just paid another LLC to do the work in the building, and the landlord actually just paid themselves and didn't actually spend any money, then the MCI can be denied. And MCI will also be denied as long as there are housing code violations in the building. If the violations are category B or C, some folks may be familiar with that. HPD they rate every violation A, B, or C. C is the most hazardous, B is hazardous, and A is non-hazardous. So if there are B or C violations in the building, the landlord has to correct and clear all of those violations before the MCI can get approved. And then finally, if fewer than 35% of the units in the building are rent stabilized, then the landlord can't get an MCI at all. And that also is new. And these were really important victories won by the tenant movement, because for a long time, MCIs were really the back door to landlords being able to jack up the rent in rent stabilized apartments. And this puts some limits on it. There's still a ways to go, but this does at least cap some of the worst practices that we used to see, where landlords might decide that they were going to redo the entire lobby in, gold flake, just so that they could impose $700 a month rent increases on every tenant. Okay, let's move to individual apartment improvements, IAIs. So they are what they sound like they are. It's an improvement to an individual apartment. Um, it must be something that is an improvement, so not repairs or maintenance, right? So not if the landlord replaces the damaged bathtub, but if the landlord puts in a jacuzzi, that would count as an improvement. If the apartment is occupied, the tenant has to consent in writing. So a landlord can't do this while you live there unless you agree that you want this improvement and you're willing to have your rent go up. For that reason, there's almost never an IAI in an occupied apartment. Landlords wait until the apartment is vacant and then they do the work because they don't need anybody's permission then. There's no tenant. And what's more, unlike MCIs, they don't have to get permission from DHCR. They just tell DHCR in their next registration, the rent's higher now because I did improvements. This for years has been ground zero for fraud, deregulation, because again, if a landlord could get an apartment vacant, all they had to do was say, I did $90,000 worth of improvements in this apartment. And coincidentally, that's just enough improvements to raise the rent high enough to deregulate the apartment. Uh, and there you go. And the burden would be on the tenant who moves in after that to try to do the detective work to figure out whether that work was actually done. We're not out of the woods on that yet, but some major important changes that took place in 2019 include that now a landlord can only do $15,000 of improvements in an apartment in 15 years. To be clear, they can spend as much as they want on apartments. They can only credit the 15,000 towards a rent increase. And they can only be spread over 3 improvements. So no more, 90, I spend $90,000 on a really nice refrigerator. Once they do that, there's a formula like with an MCI with different numbers. But like MCIs, it depends on the size of the building. If you're in a 35 or fewer unit building, your rent goes up by 168th of the cost. And if you are in a bigger building, it's 180th of the cost. And if you're wondering where those numbers come from, those are multiples of 12. So it is, I don't remember off the top of my head, maybe somebody else does, but that's the number of months in something like 20 or 30 years. So the idea is to spread the cost of the improvement over all of those months. There is a provision of the new law that says that improvements have to be reasonable, or the cost, the amount paid for the improvement has to be reasonable. It's a little awkward because unlike for MCIs, again, there's no approval process. So the burden falls on a later tenant to try to make the case that maybe the landlord overspent for whatever improvement they did. So that's not an easy thing to do. All right, shifting gears. Apartments can leave rent stabilization. They can be deregulated. And before 2019, and this was arguably the biggest, most important change to the law in 2019, before 2019, an apartment would become deregulated if the rent hit a certain threshold, which changed at times, but as of 2019 was at about $2,700. Uh, if the apartment was vacant at the time, uh, it could be deregulated out from under a tenant who is living in the apartment if the rent hit $2,700 And the tenant also had a high income, $200,000 or more. This was how hundreds of thousands of apartments left rent stabilization. Combined with the individual apartment increases, landlords would claim they might claim, they might do a little and claim a lot, improvements in the apartment in between tenants until they got the rent up to 2,700, and then they would rent it to the next tenant as a market rate unit. This was not only a way to deregulate apartments, it actually made New York City a focus point in the entire world for for investors. After the dot-com bubble burst in the early 2000s, and investors were looking for other ways to get a high return on their investments, they started zeroing in from all over the world on buying rent stabilized buildings in New York City, doing everything they could to get the tenants out, claiming individual apartment improvements, deregulating the apartments, and then selling the now market rate building for 2 or 3 times what they paid for it. And this was, uh, you know, this was a huge phenomenon. Um, and uh, when the financial crisis hit in 2008, a lot of those investors were caught flat-footed and they couldn't make their mortgages. And folks may remember there was just a wave of foreclosures of apartment buildings, often owned by investors from Israel or London or Australia. Um, as of 2019, as of June 2019, this means of deregulating an apartment, it's no longer available. Doesn't happen. Apartments stay rent stabilized no matter how high the rent goes. It doesn't matter if the rent goes up when there's a tenant there. Doesn't matter if the rent goes up when it's vacant. Doesn't matter if the tenant, what the tenant's income is. You cannot deregulate an apartment by raising the rent anymore. There are still ways to deregulate apartments. Like we said at the beginning, if the apartment's only rent stabilized because it's part of one of these tax benefit programs, like J51 or 421A, the apartments get deregulated when the program is over, which is in 10, 15, 20 years. The other way that apartments can be deregulated is called substantial rehabilitation, which basically means landlord gut renovates the building. And the idea there is the renovations have to be so basic and so extreme that essentially the original apartments no longer exist. And the apartments that are in the building are now new apartments. And specifically, that means that the landlord has to replace at least 75% of the building systems. And building systems are things like the plumbing, the electricity, the gas, the heat, the roof, et cetera. DHCR has a comprehensive list. And also the building has to have been at least 80% vacant when this happened. So this does happen, and it's even more often for buildings that look like they should be rent stabilized and even have rents below 2,700. If you go digging back through their history, often it's a substantial rehab. That is the reason they're deregulated. Those things can still happen. Landlords can also not deregulate an apartment, but take it out of the rental market, either by taking it for their own use. They themselves or someone in their immediate family is going to move in and use it as their primary residence. They're going to live there full time. They can take it back if the tenant is not using the apartment as a primary residence. They can evict rent-stabilized tenants if they plan to demolish the building. All three of those can only be done at the time somebody's lease is up. And they can only be done um, if the landlord proves their case in housing court. And in fact, for demolition, they also have to go through DHCR and get permission. So the demolition is not an easy path for them to follow. Owner use uh, used to be a real tool for fraud before 2019, when it was worth a lot of money for a landlord to get an apartment vacant. It was pretty common for landlords to say, I'm taking your apartment because my son-in-law is going to move in. And then, swing by 6 months later and the son-in-law is not living there and the apartment has been deregulated and there's a tenant paying $5,000 a month. Since 2019, there's not as much incentive for this. So at least anecdotally, we don't see as many owner use cases as we used to, but they do still happen. And in fact, sometimes landlords are actually honestly trying to get an apartment for their own use. Tenants can also be evicted from rent stabilized apartments for cause, such as not signing a renewal lease within 60 days of when you get it, violating the lease or creating a nuisance, or failing to pay rent. Right? And of course, all of those things have to be proven in housing courts. Rent stabilized tenants, in addition to having these protections, also have certain tools that they can use that aren't available to other tenants, market rate tenants, or even tenants covered by good cause, right? And most of those are processes, applications, complaints that you can file with DHCR, right? So the first one is rent overcharge, right? If you have reason to believe that you're being charged more than you should be based on the legitimate rent increases that the landlord could take, then you can bring a complaint, an overcharge complaint at DHCR. And if you win, not only does your rent get reset to the correct level, and the landlord has to pay back all of your overcharge, if DHCR finds that the overcharge was willful, meaning the landlord did it on purpose, they're going to have to pay you triple damages. You also have the option to bring an overcharge claim in two other ways. One, you could bring a lawsuit in Supreme Court and sue the landlord and get the court to rule on whether you're being overcharged, or you can bring it up as a defense if you get sued for non-payment in housing court. So landlord says you owe rent, you say as a defense, you're charging me the wrong rent, and you can litigate it there. There are pros and cons to these different avenues. Making a complaint to DHCR is the easiest way to go. It's all done on paper. You don't have to take off work. You don't have to go to court. It's a fairly simple procedure. It's easier to do without a lawyer. DHCR moves extremely slowly. Could be 2, 3 years before you get a ruling on this. And in the meantime, you've got to figure out, are you going to keep paying the higher rent? Can you afford to pay the higher rent? And if you can't, you're going to wind up in one of these other avenues. Our experience has always been that you have a better chance of winning if you fight it in court, but only if you're able to have a lawyer, of course. And so that's a big if. Tenants can also make complaints if the landlord doesn't give them a renewal lease. As a rent stabilized tenant, you're entitled to a renewal lease, and it has to be sent to you between 5 and 3 months before your lease expires, between 150 days and 90 days, right? And then you have 60 days to return the lease, sign and return the lease. If you don't, then the landlord can say, okay, you chose not to sign your lease and I can evict you. Landlord has to return a signed copy with their signature on it, 30 days. This very often doesn't happen. But fun fact, and one of my favorite parts of the rent stabilization code, if the landlord doesn't offer you a lease, that's their problem. The law says if the landlord doesn't offer you a lease, your old lease just continues indefinitely, same rent until they offer you a lease. And even when they offer you a lease, still got to wait 90 days before that kicks in. So if a landlord doesn't give you a renewal lease, you should say thank you. Send them a thank you note. I mean, don't, because then they'll probably send you a lease, but all they're doing is giving up the rent increase, right? And if they do eventually offer you a lease and it's late, they can't go back and say, I'm going to give you two rent increases because I waited an extra year. Um, no, they can, they miss their chance. They can get one rent increase. And what's more, you get to choose whether you get the percentage for the year when they actually send you the lease or the percentage that was in effect for the lease for the year when they should have sent you the lease. So you can pick whichever is lower. And that is written in so that landlords don't game the system and say, I'm going to offer you a lease. This year the RGB is not allowing large increases. I'm going to just delay sending you your lease for 4 months so I can get the bigger rent increase that the RGB will approve next year, right? So the people who wrote the law back in 1969 were smart. They thought of that. It doesn't work. Uh, Finally, rent stabilized tenants can do something that no other tenants can do. You can make a complaint to DHCR if there are conditions in your apartment or the building or services not being provided. You make the complaint, DHCR sends an inspector, and if they find that your complaint is true, then they roll your rent back by one increase, right? So your last lease, and they freeze it there until the landlord proves to them that they've fixed the condition. Um, and you can do this the same way that you do the other complaints. You do it on paper, you mail it to DHCR, you sit back, you wait for the inspection. The landlord, of course, can try to submit proof that they did the work. And, it's also true that it's not a huge reduction in rent. It may be only a couple percent. And that, while that's a nice thing, is not the kind of reduction that tends to stress landlords out. It's not the kind of thing, it's not like a rent strike where they're going to be alarmed and feel like they need to do something quickly. Okay, moving on. Another great thing about rent stabilized apartments is succession rights. Because the purpose of rent stabilization is to provide stability. It's right there in the name um, for housing, and that means stability across generations. So the law provides that family members can take over the apartment when a tenant either dies or moves out. This generally requires that the person succeeding has to have lived together with the former tenant for at least 2 years, and it has to be the 2 years right before they moved out or passed away. Right? So, it'd be the 2 years leading up to the point that you're trying to succeed. That's 1 year if the person trying to succeed is disabled or a senior citizen. And this person succeeding has to have a family relationship with the person they're succeeding to. DHCR and the Rent Stabilization Code define that as I actually should change this. This is incomplete. You have to be a spouse, a child, a sibling, or a parent, or a grandparent or a grandchild of the person who died or moved out, or even if you don't have a blood or legal relationship to the person, if you can show that you had a family-like relationship with them, you can still succeed to the apartment. And that usually involves making a very detailed showing with a lot of documentary evidence of emotional and financial commitment and interdependence. So That tends to be things like shared expenses, shared bank accounts, naming each other as beneficiaries of insurance, being caretakers for one another, having healthcare decision authority for each other, living together in the way that family members do. Um, you know, it can be very difficult to make that showing, but it's a very important advance, and it is the result actually of the LGBTQ rights movement. And in 1989, when same-sex couples could not get married in New York, uh, a same-sex a man whose life partner had passed away, a man named Brashi, sued for the right to succeed to his partner's rent-stabilized tenancy and said that it was discriminatory that he couldn't. And the Court of Appeals agreed and created this pathway for people to prove that they had a family-like relationship. And shortly after that, it was actually codified into the law. And finally, the Rent Stabilization Code prohibits landlords from harassing tenants. The New York City law in 2008 also made it illegal in general for landlords to harass tenants of any kind, whether you're in a market rate or a regulated apartment. The Rent Stabilization Code has a slightly different definition of harassment and a different pathway to file a complaint. So it can be useful to pursue the rent stabilization DHCR path instead of going to housing court with a harassment claim. So under rent stabilization, harassment means that a landlord either discontinues required services. In general, when we talk about apartments and we say services, we're talking about utilities. But for rent stabilization, a service is basically anything that came with the apartment at the time you moved in. Right? So if you had roof deck access, if you got to go in the backyard, if there was a washer dryer in the basement, those things have to be continued. It's harassment for a landlord to file baseless court actions against you, or file false statements to DHCR, or do anything to interfere with the tenant's quiet enjoyment, or any other acts that are intended to make the tenant move out or waive their rights. And that part is similar to the language we have in the city harassment law. Um, Unlike the city harassment law, you can litigate this by making a claim to DHCR again, which is, an easier path to go. If harassment is found, the landlord may have to pay a money penalty that goes up for additional offenses, and your rent can be frozen until whatever the landlord is doing for harassment ends. Okay. Thank you for listening to me talk for a very long time.